rape of a child and indecent assault and battery on a child. The case has been through the appeals court, which affirmed the convictions, and the case is here on a grant of the defendant's application for further appellate review. The case presents basically two issues, both involving the doctrine of first complaint. The first is whether it was error to admit evidence of a second complaint under the doctrine of first complaint. We say it certainly was. And the second, as raised by this Court's amicus solicitations, is whether the doctrine should be abolished or amended, and the matter governed in future cases by the ordinary rules of evidence. In our view, it should be. I'd like to turn first to the error in admitting the second complaint under the first complaint doctrine. So since that's our argument for reversal on behalf of this defendant in this case, of course, that argument turns on the law as it existed at the time of trial. That's shown by the King decision itself, which applied the former fresh complaint doctrine in analyzing the error in that case. And then I'll turn to the policy question about the viability of the doctrine, although I'm not sure that the Court will reach that question on a panel consisting of such a momentous question on a panel consisting of four justices, but I will certainly address it if the Court likes. As to the error under the first complaint doctrine, this is really a pretty straightforward error in this case. The first complaint in this case, which alleged a touching, was made in 2002, and being the first complaint, that was admissible. There was no objection to the introduction of that complaint. But defense counsel vigorously objected to evidence of the second complaint, which was made 3 years later and alleged a rape. And here's what that testimony was. The complainant testified that in 2005, she told her mother about a rape. That's the language used in the testimony. And her mother then took her to the police. And the complaint was then confirmed by the mother, who testified that in 2005, the complainant told her additional information about the incidents, and she then took the complainant to the police. Now, I don't think there's much question that the testimony of the two witnesses went to the same conversation. They both testified it took place in 2005. They both testified that after the conversation, they went to the police. So the mother's testimony certainly related to the complainant's second complaint, which the complainant testified was of a rape. We say the admission of the second complaint evidence was certainly error under the doctrine of first complaint. Why? It wasn't the first complaint.
Well, was it admissible for any other reason? That's really the question, or part of the question, isn't it? Is it admissible for any other reason what happened in 2005, these conversations that led to the complainant going to the police?
Well, the appeals court suggests two possibilities. The first is the Kebro decision, which permits a second first complaint in very narrow circumstances. And the other is the notion that this somehow served to rebut a specific theory of the defense, which in our view was not the case. Let me address those.
In your view was what?
Was certainly not the case.
Oh, okay, because I'm looking to their language. They talk about the defense being that these 2002 allegations were made for the purpose of, they were false, and they were made for the purpose of getting out of the house and moving in with the grandmother.
Let me address that first in that case.
Okay.
If I can find my notes on this point. The appeals court made, in our view, there are two problems with the appeals court's analysis of this issue. The first is that they proceed on incorrect factual premises, and the second is that that this rebuttal notion would have required a finding by the judge that never took place, since the situation, this rebuttal notion, is completely hypothetical in this circumstance. So on the first point, the erroneous factual premises, the appeals court makes these assertions in its opinion. They say that the second complaint evidence was admissible as a sort of rebuttal to rebut the defendant's theory of the case, which the court says that was that the complainant fabricated the allegations in order to move back to her grandmother's house, and which the court says was a highly contested issue, those 3 points. The first point, the matter of the complainant wanting to go back to her grandmother's house, this was not the defendant's theory of the case, which is the language the court uses, nor was it even a specific theory of fabrication argued by the defense at all. So the case is very unlike the Urana decision, where the specific rebuttal of a specific theory of fabrication arises.
You say that, but I've turned to the cross-examination of the critical witness, which was the girl,
Yes.
the alleged victim. The very first question asked by defense counsel: before you moved into Mr. Aviles' mother's house, you lived with your own grandmother, is that right? Yes, you had lived there longer than you lived at Mr. Aviles' mother's house, is that right? And would it be fair to say that you didn't want to stop living at your grandmother's house? Those are the first three questions that were asked of the alleged victim as part of the cross. Why
That's
does
right.
that not permit the inference that you're making the argument that she made the allegation in order to move back with Grandma?
If that were so important to the defendant's theory, and were indeed his theory of the case or a specific theory of fabrication, I think that probably would have been mentioned in closing argument. There's no mention of that in closing argument. This alleged specific theory was not mentioned in any opening statement. Defense counsel didn't make an opening statement.
Well, maybe it wasn't mentioned in closing because now there was evidence of the 2005 allegation, which essentially rebutted the recent the fabrication theory. I mean, rebutted this motive to move out of the house. I mean, maybe that's the back and forth of the trial.
Well, perhaps, but it certainly wasn't the defendant's theory of the case, as the appeals court
All right, fair
put
enough.
it. The theory of the case was this complainant is not credible due to oddities and
But apart from
incongruities.
what's the theory of the case, which in the absence of opening, the Commonwealth may not know until closing when it's too late. In view of that cross, would that not have, I mean, I guess it was in before the cross, but.
That it was. Yes, it was, Your Honor.
But apart from that, in view of that cross, would it not have been appropriate then for the Commonwealth to have offered it, to say they're suggesting that the motive was to go back to Grandma's house and that motive would not be present because in 2005 she was already living with Grandma?
You're absolutely right that it might have been appropriate it would have been appropriate to offer it, but what the appeals court's analysis omits and eliminates is what would have happened if this situation had played out in that way. What would have been required in that situation is the judge would have had to make a factual finding as a matter of discretion that this evidence was more probative than prejudicial and that there was a need for this evidence on rebuttal. Now, because the evidence was the second complaint evidence, the evidence of the allegation of rape, had already come in before any of this happened. That was the first thing that happened. It was mentioned in the prosecutor's opening. It was elicited by the prosecutor on direct examination of the complainant. Because all that evidence is already in, and it was not offered for rebuttal, the Commonwealth didn't offer it for rebuttal, so the judge was never given an opportunity to make a factual finding as a matter of discretion as to whether this evidence should come in. And let me cite the court a case on this point. In the Dargon case, in footnote 12, the Commonwealth offered evidence of I believe a later complaint was offered through, I think it was a medical record. The Commonwealth, it was admitted on one theory, and the Commonwealth argued on appeal that it was also admissible as a prior consistent statement. The court said no, it wasn't offered on that basis, so the judge never made a factual finding that there was any claim of recent fabrication. So these are not things that, I'm aware that there's a rule that says a judge's ruling can be upheld on a basis that's different from the one below. But that rule does not apply in circumstances where the alternate proffered basis for the ruling would require a factual finding by the judge as a matter of discretion. And that's what would be required in this situation. The judge would have, as I say, the scenario that we're talking about in terms of this being rebuttal evidence is purely fictional. The second complaint evidence came in the first place. It was noted in the prosecutor's opening. It was elicited by the prosecutor on direct examination. So, I mean, it was already in. It was not rebuttal evidence. It came in the first place. But even in the hypothetical, the fictional situation which the appeals court uses to uphold the ruling, this would have required a factual finding by the judge as a matter of discretion. That didn't happen. It can't be upheld on that basis. Let me say a word about the Kebro case, which the the appeals court relies on. The Kebro case stressed that the Kebro case allowed, in narrow circumstances, a second first complaint. But it stressed that it was only to be allowed in narrow circumstances like those presented in that case. And the circumstances in that case involved two different periods of abuse and a complaint made at the end of each of those periods. Now, the different periods language, I'd ask the court to note, appears at two places in the opinion, at page 289 and 296. This appears in our application for further review. In this case, there was only one single period of alleged abuse.
But they're two separate offenses, aren't there?
Yes, Your Honor. That was the case in Kebro as well. The first period in Kebro dealt with indecent touchings, as in this case, well, which were also alleged in this case. The second period in Kebro dealt with alleged rapes. That's the second thing that's also alleged in this case. But in this case, there's one period of abuse of alleged abuse. That's the single period of 3 months when the defendant, when the complainant and her family lived with this defendant. So what's different about this case doesn't fit the terms of the Kebro exception because there was no second different period of abuse to justify the admission of a second complaint. So that's the first thing. The second thing is there was a certain matter of fairness involved in the Kebro case, which is not present here. In the Kebro case, the second period of abuse had not even occurred at the time of the first complaint. It occurred after the first complaint, as indeed the trial judge noted in his ruling admitting the evidence of the second complaint. So as a matter of fairness, there was no way that the complainant in the Kebro case could have reported the abuse, abuse from the second period in the first complaint. Here, on the complainant's account, the rape had already occurred at the time she made the first complaint. So certainly she could have reported the alleged rape in the first complaint. Now, this impossibility and fairness point that I'm making, this is not a part of the court's rationale in the Kebro decision. But I think it's implicit in the decision, and the court does recite the judge's findings on this point. The fact that she couldn't have made the report of the alleged rape at the time of the first complaint. So I think it's a fair, particularly since the Kebro decision is supposed to be narrowly construed, because otherwise we'd have the rule is first complaint, otherwise there'd be a great big hole to admit evidence of second complaints. I think that's a fair, the fact that the complainant in the Kebro case couldn't have made a report of rape at the time of the first complaint, that's something that can probably be considered and something that very much distinguishes this case.
Let's assume you were right. This evidence should not come in. The jury then would have heard a first complaint that there was an allegation of an improper touching.
Yes.
And would have heard nothing to tell them how the charge of rape ultimately reached the police.
That's correct.
And would probably believe that, well, I don't know. I mean, how is a jury going to evaluate the child's claim without understanding, at least as to rape, without understanding how the claim of rape ultimately reached the police and the prosecutor?
Well, I think there are 2 points to be mentioned here. The first is that I believe it's the Stukich case says it's irrelevant how the case was reported to the police. That's not something that the jury needs to know, and indeed that was an objection made by trial counsel in the pretrial colloquies in this case. Let's see. There simply isn't. The second point is this is a result of the doctrine of first complaint. The first complaint, it gives the Commonwealth a number of benefits, and it gives the defendant one thing, which is only one complaint's coming in any case. So there may be a second complaint. Defense counsel, contrary to what the Commonwealth argued in the appeals court, would not have been able to argue, no, there was no second complaint of rape. But the limitations of the doctrine are such that they get one complaint. That's what comes in, and there may have been a
They
second
get one
complaint.
complaint which otherwise would not be admissible for any reason, right? So that's it. This is the benefit. You get something in evidence that in any other case wouldn't be admissible.
Right.
So it's not
Right.
admissible for any independent
And
reason.
it certainly wouldn't have been admissible as any other sort of offense. It's only allowed in these sexual offenses. So this is the part of the balancing and the trade-offs that were done in formulating the doctrine of first complaint. And I think that's the answer to your question.
All right, thank you very much, sir.
Thank you, Your Honor.
Good morning, Your Honor. May it please the Court, Bethany Lynch, Assistant District Attorney for the Commonwealth. I'll first address the issue of what defense calls a second complaint. The Commonwealth would rather characterize it as a first complaint of a second and an independent assault on this victim.
But is that really the case? I mean, Kebro really is different than this, isn't it?
It's different in that the assault of the rape in Kebro hadn't occurred at the time of the first complaint.
Right.
But which is a difference. But in this case, the victim was 8 years old, and she revealed that the defendant touched her in 2002, and immediately her mother moved her out of the house. She didn't reveal anything about the later rape. So, yet that rape had occurred.
It occurred before
and it
she
did occur
made the complaint
before,
to the mother.
But in the defendant threatened her as to the rape.
And that
as
came
well.
out.
And that came out at trial.
Sure, that was appropriate to come out.
Right. The victim testified that she was afraid to report the rape because the defendant said that he would harm her mother. So I would argue that that is, in a way, analogous to in the inability to report the rape at that time.
But that came out in testimony, and that was
did come out in
appropriate.
testimony.
Appropriately came out in testimony.
It did, but after she was allowed to testify that she reported the rape, she was allowed to explain the delay in the report. And defense is arguing that she would not be allowed at all that neither the victim nor the mother would be allowed to say anything about any report of the rape. The victim would be able to testify about the rape,
Well,
but not explain her delay, and the delay was as a result of the fact that she was afraid of this defendant. He had threatened her. He had told her that her mother told him to rape her and that he would hurt her mother if she told anybody. Within a very short period of time, she told her mother that the defendant was touching her. But the mother on first complaint testified in a very limited fashion, only that she received this complaint, but that the girl would not tell her any specifics. That she was scared and frightened and crying, and all she would say is the defendant touched me. So, which he had done, and he was charged with indecent assault and battery over diverse dates and times. He was also charged separately with the rape. And I would argue that that's an important distinction to make here. He was charged with a separate crime that occurred while the victim was living in the apartment, but did not, and so it was not years later, as in Kebro. I think the difference that you would be imposing in Kebro, if the timing of the assault were the definitive factor, would be that the victim would need to attempt to report many times. She would have reported, and if nothing happened and the abuse continued, then she would be allowed to have another first complaint if more sexual assaults happened afterwards.
But, okay, let's look at this. I mean, this first complaint, this is evidence that is not admissible in any other type of case. So this is a very
Right,
limited
complaint
exception.
evidence.
First
Yes.
complaint evidence. So
Yes.
the first complaint, I told my mother X. Right, that comes in.
Right.
Several years later, I told my mother X, yes, but I told her then Y. That also happened too. And then maybe a third time, and something else happened as well. So as long as it's a slightly different disclosure, then there's no limitation to the first.
It has to be a disclosure about a different crime.
Well, a different crime could take place in the same sequence.
It could.
I told my mother X, but I didn't tell her X plus Y plus Z. It happened later that day, or a separate crime, but in the same course of conduct. You could get each of those pieces in under this doctrine?
I would argue that you couldn't get each of those pieces in under the doctrine. It would be a factual analysis that the judge would have to make before the evidence was admitted. And you would have to look at, if the initial complaint was that the defendant touched me over a course of time, and, touched me, indecent assault and battery was the first complaint.
Right.
And then nothing happened. Nobody went to the police, nothing happened. And then 3 years later, when the victim is out of the situation and when the motive to fabricate is gone, she's now at her grandmother's home. 3 years later, she sees the defendant's picture and then reveals a much more violent assault that she had never spoken about before or never even implied happened before. I think you would have to use a factual analysis, and the judge would have to have some discretion there. I'm not arguing that each individual touching, if it was a course of molestation. In this case, he touched her multiple times. She was a young child, and it was charged over diverse dates. It was one charge, and that was what she revealed in 2002. 3 years later, she revealed a much more violent sexual assault on her, a rape. And so with the Commonwealth's position that Kebro allows a second complaint with a justifiable reason. And in Kebro, the reason was that they couldn't have reported it because it hadn't happened yet. But in this case, I would argue that this victim couldn't report it because she was so scared of this defendant.
Even though the offenses all occurred during the same time period.
Right. I think that limiting it temporally is not fair to the doctrine. That the doctrine is in place so that the victim can explain the delay, and that the victim can explain why she didn't go to the police, why there was no immediate hue and cry. That's the whole rationale behind the first complaint doctrine. And so to say if you don't tell, and again, I think it is important in this case in particular that this is a young child, but if she doesn't tell every single thing and every offense that happened to her, and an escalating offense at that, in this case, she revealed enough to get away from the defendant. And that's where she stopped. If she then, years later, reveals that he also committed a violent rape against her, to deny her the ability to
She certainly can testify that the crime was committed, for sure.
Yes.
I mean, that's not the issue.
Yes.
The issue is whether this additional testimony can come in to corroborate. Something that wouldn't be admissible in any
Right.
kind of criminal case can come in to essentially corroborate
the report being made. And I think that I don't see that in this situation where it is a separate, completely distinct crime, even though it did happen before the first report to the mother. This was a separate violent crime that she was threatened. She didn't report that she was threatened by the defendant at all about the indecent assault and batteries. It was only when he committed this rape against her that he threatened her mother.
So this is the basis on which you say it was admissible.
Well, I say that it should be admissible as first complaint.
As first complaint
As first complaint. In the event that it would not have been admissible as first complaint evidence, then it would also have been admissible in order to counter the defense theory of fabrication in this case.
And how did that defense theory arise?
Well,
how was
it
it
may
known
not
in
have
advance?
been.
How was it known of in advance that we understand the prosecutor actually mentioned this evidence in opening?
She did. Well, she was the way that this came up in this case is that the prosecutor was offering the mother. The girl reported to her mother, to her grandmother, that she had been raped in 2005. The grandmother apparently told the mother, and the mother's testimony was limited to such a degree that all she was able to say was that she received further information in 2005 and they were taken to the police. So it was, in a sense, a preemptive evidence to avoid the possibility that
Possibility of a defense, not the theory of the defense.
Right,
Avoid a
because
possible defense?
Well, a possible defense in a sex assault case with a child and a grown man, I think that it's fair for the Commonwealth to presume that part of that defense could be she's making it up.
Well, of course that's going to be the
Right,
defense,
and
but
that's
that's
really
different than the defense you're talking about now.
Well, it is and it isn't. I mean, fabrication.
What you're talking about now is the motive was to get out of the house and to rebut
Right.
that. So that's different than making it up.
Right, but now she's testifying Then she's going to testify about a rape that she never mentioned before, and the Commonwealth knew that. They knew that she was going to testify about this rape, so it created this false impression that she never told anybody about it. Had the Commonwealth not been able to at least say, I told my mom and we went to the police.
But isn't that, wouldn't the second complaint be independently admissible if the defendant suggests recent contrivance or recent fabrication? Doesn't it have an independent basis for admissibility?
It could have an independent basis, I would argue, if the defense brought it up.
Yeah.
But
So you introduced it as a preemptive
well, and as a
matter,
way
but-
to explain the delay, because the victim shouldn't have any negative inference upon her from the jury.
Why is the
that
delay relevant? Why is the delay relevant? The question is what happened at a certain period of time. Why is the delay relevant? Even relevant to this case? Or why is it how it got to the police department even relevant?
Well, I think the jury was going to hear that these actions happened years before.
2002.
And that in 2000, the trial was not for 5 years. It was in 2007. So I believe the Commonwealth has the right to at least put in some evidence of what took so long. The victim first reported this in 2002, the indecent assault and battery, to her mother. The trial was more than 5 years later.
So you say the Commonwealth can, as a matter of its presentation, explain...
In order to explain the delay in coming to trial, in order to... perhaps I'm not following your question.
No, I'm just trying to figure out why it's relevant that there's a delay in trial between the time of the offense and why it's relevant.
Why the delay in reporting is relevant?
Why, I mean, the issue is what happened back in 2002. That's the issue.
That is the issue.
And the fact that the trial's taking place in 2005 or 2006, why is that relevant to what's happened? Why do you have to, does the Commonwealth have to explain why the trial is happening now? Could be many reasons. It could be a mistrial. It could be lots of reasons why it hasn't gotten to trial until this point.
I would agree that there could be many reasons that the case was delayed. But I would argue that in order for the Commonwealth, again, it is a preemptive. It's in order to explain why it took her so long to tell anybody about.
I mean, it certainly may have been an issue on rebuttal, for sure.
Right.
Or if the door is opened, Katie, bar the door. I mean, if the door
Right.
is open in cross-examination, a lot of this stuff could come in. But this is all being done in advance, and that's a little bit why.
Well, I know. I mean, the Commonwealth does put in evidence in advance of the defense case in other situations, and so I would argue that that's what this is that presuming that the defendant wasn't going to leave that alone. The Commonwealth would have had the right to explain the delay before the defendant was allowed to cross-examine and say, but you didn't tell anybody for over 3 years, did you? And then to come back, I don't see that it's beyond the Commonwealth's purview to be able to step in before the defense comes forward with this.
Why not file a motion in limine to request that and flush
well,
it out?
the motion in limine was filed by defense counsel.
Oh, but by the Commonwealth. Oh, okay.
Well, I mean, it was filed by defense counsel
Yeah.
to exclude it, so the situation was discussed beforehand.
And it was known at that time that the defendant was going to raise the issue of recent
Well,
fabrication?
I know that it was known at that time that the defendant did not want the mother to be allowed, either the mother or the victim to be allowed to testify about the report of the rape at all. And so the judge, in looking, and at the time that Buelterman case had just come down as well, and it allowed testimony very limited on a first complaint where there was no substantive repetition.
Well, what if his motion had been allowed, his motion in limine had been allowed? Wouldn't that have precluded him from raising the issue of first complaint, or of recent fabrication?
I would hope so.
Yeah. So it seems to me that one of the things that the Commonwealth can do is say, okay, we agree to that, and we won't present that evidence, but you're not going to get into recent fabrication.
And I suppose that could have been done in this case, but under this.
Could you refresh my recollection? Let me just
Certainly.
ask a slightly different question. I'm sorry, I just don't remember what we said in King. Could you have introduced the second complaint without introducing the first complaint? Introducing the second complaint as first complaint?
No, I don't believe so under King.
Because it's the second statement?
Because it was a second statement.
Even if it was limited to the second incident?
I believe so. Because I believe that under King, the doctrine, as it was first stated, was that there was one complaint, and it was the first complaint made, period. Okay. And then case law developed after that, including the Kebro case and including the Marungu case, which where the first complaint was not, the first complaint doctrine under King was insufficient in terms of a case where there were under Kebro multiple complaints or multiple charges, multiple offenses committed by the defendant, or under Marungu where technically the first complaint witness would not have been the appropriate witness due to the relationship to the defendant. In those cases, the first complaint doctrine under King had to be expanded to take these things into consideration. And so it's my understanding of King that under King, the first complaint of sexual assault is the first complaint. But King also says the first complaint of the assault, and it uses the singular. So I believe that leaves the possibility that are there more than one separate and distinct assaults? There's a possibility that a separate and distinct first complaint for each assault would not be inappropriate. If the court has no further questions, I would rest on my brief. Thank you, Your Honor.